Good morning, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder, Mr. Rojas told me this morning that you have the intention of trying to hire an attorney.
Yes, ma'am.
Okay, so I need you, if your family or you is going to do that, I need that done within the next 30 days.
Yes,
I'm going to reset your case one time. Obviously, I can't have you just sitting in jail while we're not doing anything on your case. And so Mr. Rojas will remain your attorney until or unless you hire someone. If for some reason it doesn't work out that you hire someone before that next court date, then we're going to move forward with Mr. Rojas, okay? Okay, you can go back with the bailiff. Thank you. Ms. Pratt? Ms. Pratt, come up, please. Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney
Okay,
while I was in jail, so that's why I can't urinate.
okay. Because I have notification,
The lady came from Vienna to put the patch on. It was real late at night in jail.
so I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what that's not true. So I'm going to
I
find,
had the paper at home. I didn't bring it with me.
well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
You change it.
Yeah,
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
you being in the parking lot doesn't do any good because I'm not in the parking lot, am I? Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your chair.
I've been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff. Good morning, sir. Are you Robert Hebert?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hebert, in cause number 25 DCCR 0740, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from February 11th of 2025. And how do you plead to that charge?
Okay.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Just do what they charge you with. Yes.
Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
The paperwork on the tablet, did y'all go over it? And do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
That's correct.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hebert is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. See, Brandon Henderson.
I don't know, they'll take it, they'll figure it.
Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
Will your client waive the formal reading of the indictment?
Anyway, Your Honor.
Mr. Mills, in cause number 25, DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer from November 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the
Yes.
state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
I understand.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am, I understand.
State tenders number 1.
Objection.
It's admitted. Any evidence that Mr. Mills is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of that plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices
Yes, ma'am.
qualify. I have to read the whole thing to you.
Oh, yes, ma'am.
That's okay. That's okay. And see, now I'm going to mess it up because I got, no, you're fine. You should just, that's okay. Just read it to make sure you understand what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Just for the record, Judge, I believe Mr. Nichols has agreed to dismiss his misdemeanor case in County Court 2.
We have.
Okay.
Okay, then I'm sure Mr.
And
Nichols will
obviously-
take care of that, and they'll, that way you'll be able to not have that holding you out there anymore,
Okay,
okay?
that's what.
On that,
All right.
on that judge
Good luck to you,
case.
sir. You can go back with the
Thank you very
bailiff.
much.
Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp, in cause number 25, DCCR 0916, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025. The indictment alleges you were previously convicted of theft, a third-degree felony, January 20th of 1987. Also on that same date, aggravated robbery, a first-degree felony. And after those were final, you were convicted of possession of a controlled substance, a second-degree felony, October 9th of 1998. What that means is that if you go to trial in this case and you're found guilty and those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0917, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon Those same prior offenses are listed in that indictment as well, again, making this for punishment purposes, if convicted, a habitual offender status, which means minimum 25 up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter pleas of guilty in your cases, to proceed on, I guess that would be count one only.
Yes, Your Honor.
So just the offense, not the underlying prior offenses. So go on count one only for a 15-year term in the institutional division of the Texas Department of Corrections. You've got every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter pleas. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Sharp, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Sharp, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes, ma'am.
So talk to that attorney and they'll file the appropriate paperwork, and then as soon as they do that, I will set it for a hearing on a bond, okay? Good morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again for punishment purposes. That would make this a second degree felony offense if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file with the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so.
Yes, ma'am.
Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay?
Thank you.
All right. Yes, good morning. You're Norberto Armenta,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
So, he will, Your Honor.
Let me,
And Judge, if we may proceed on what I have numbered as 1, 2, and 3, my position on that is it's the first paragraph, the second paragraph, which is a jurisdictional paragraph to get us to the DWI third, and then a regular felony prior.
Okay, so technically two
Technically 2. I just
counts with
didn't know
the
if-
second paragraph.
how it kind of looks like a paragraph on its own, but it's just jurisdiction.
Okay. And so in cause number 25, DCCR 0168, you're charged with the third degree felony offense of driving while intoxicated, third or more. That's from April 25th of 2024. The indictment alleges you were previously convicted of driving while intoxicated February 5th of 1998 in Harris County, Texas, February 6th of 2008 in Harris County, Texas, and then again September 8th of 2023 in Harris County, Texas. And then the second count in this indictment alleges that you were previously convicted of possession of a controlled substance, second degree felony, June 24th of 2004. And how do you plead to that charge?
Guilty.
And are all those prior convictions that I read out for DWI as well as the possession of a controlled substance true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer tablet some documents that have your signature on them. that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 12 years in prison. And I want to make sure you understand what that means is you're leaving your punishment up to me. And as long as I don't give you more than 12 years in prison, then you can't appeal. If I can give you 12, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that, and is that what you want to do?
Yes, ma'am.
It shows also as part of this agreement that the state will dismiss cause number 25, DCCR 0169, and it will run concurrently with any other felonies that you are currently serving time on. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armenta is not competent?
I'm aware of that.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. All right? You can go back with the bailiff.
Your Honor, just to be clear on the paperwork, it reflects we're not requesting probation, we're requesting a five years.
I saw that. Yes, sir. Thank you. All right, you can go back with the bailiff.
I'll be out to see.
Good morning. Are you Jarrett Matthews?
Yes, ma'am.
In cause number 23, DCCR 1211, Mr. Matthews is charged with unlawful possession of a firearm by a felon. Mr. Kimler has filed a motion asking that I reduce bond, which is currently set at, is it 100,000?
Yes, ma'am.
Let me look at something real quick. Mr. Kimler, you may proceed. Do you, are you going to call your client?
Yes, Your Honor.
Mr. Matthews, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Go ahead, Mr. Kimler.
Mr. Matthews, where do you live? Where do you reside?
Lake Charles, Louisiana.
And how long have you lived here?
Since I was born.
And you were passing through on Interstate 10 when you got this case, is that correct?
Yes, sir.
Why is your bond at $100,000? What's your understanding of all this? Put that amount?
I missed court. I had bonded out. My bond was $30,000, and I bonded out. But I had a old case in Louisiana.
Calcasieu Parish?
Yes, sir. No, Jeff Davis.
Jefferson Davis Parish? All right.
And I took time on that case.
So you received a sentence in Jefferson Davis Parish?
Yes, sir.
And how long was that sentence and when did you receive it?
It was a 4-year sentence, and I turned myself in March 18th of 2024.
All right. And then how long were you in the Louisiana Department of Corrections incarcerated?
Till about 3 weeks ago.
Okay. And so did you discharge your Louisiana sentence?
Yes, sir. I was extradited here.
And then
from
you were
Louisiana.
extradited here from Louisiana?
Yes, sir.
So if you missed a court date here, was that, to your understanding, that was a time when you were incarcerated in Louisiana?
Yes, sir. I notified my lawyer and the bondsman the day I turned myself in. Well, I notified my lawyer,
Who was your lawyer over here?
Charles Rojas.
And you let Mr. Rojas know that you were going into custody
Yes,
in
sir.
Louisiana?
And it doesn't look like it was a bond forfeiture. I think it was an at-large without proper bond because he was
Yeah, out of state.
out of state in custody, is what it looks like to me.
In any case, Your Honor, wasn't in court, wasn't voluntary, so we would ask the court to reinstate the original bond.
Ms. Molfino?
Judge, my position though is that his criminal history in Louisiana, which sometimes is difficult to tell exactly what it is
Decipher,
from where, but
translate.
it's not a single incident, it's multiple incidents involving guns and drugs, or also a suggestion of drugs in this car where the gun was located, and he was also evading officers. So just based on the fact that he does have history in Louisiana and will probably return to Louisiana if out on bond, I would just ask the court to consider that bond sufficient.
I don't know if there's a risk assessment from DPS. Do we have that, the form that you get from DPS on bonds?
No, I don't have that. The magistrates at the jail get that. I can get it if you want me to.
I might take a look at it maybe before. I know the states, I know I'm not disparaging Ms. Mulford.
Hold on, what?
It should be scanned in if it was something used to set bond.
I know they get it next door. He pulls them up to look at. That might be a better reference as far as his assessment. I think it's called a risk.
I just was looking at the criminal history.
No, there's a thing
I can hear
now
you.
that they're supposed to look at. It's a DPS compiles it like a risk assessment. for
There's
bond.
none in here. For some reason, that's not scanned into this case. And so what I can do, not sure why not. It should be if back when that bond was set, it looks like there was a bond set.
I think 30,000 was the original bond.
Right, and that was back in 2022, probably on the date of the arrest. Yeah, when he was arrested. And at that time, there may or may not have been the, that's a fairly new program. So that was not something that was in existence in 2022 when this bond was set. So they took into consideration whatever they had under the available, yeah, history at the time in Jefferson County primarily. There were some things they could look at, but not the new warrant. If everybody would just give me a second, I am going to take judicial notice of the court's file, including the probable cause affidavit. Give me a second to read that, please.
And Your Honor, we could just reset if the court wants to take under advisement to get that report.
Let me just read this first.
Did you ever compete with old girls back time? Okay. This is the crap.
Yeah, I think it's probably important that I look at this. Honestly, Mr. Kimler, I'm not sure that it's going to be a positive or a negative. I'm not real sure based on what I'm reading and what potential criminal history there is that the $100,000 bond is sufficient, honestly.
Okay.
So, I mean,
It's not my intent to get the court to raise the.
well, if you want me to look at everything, I will take a look.
Today's hearing demonstrates how important plea decisions can be in the criminal justice system. Before a defendant rejects a negotiated agreement, the court must ensure that the decision is made knowingly and voluntarily. In this case, Judge Raquel West carefully explained that rejecting the state's 15-year offer could expose the defendant to the significantly higher punishment range applicable to a habitual offender if convicted at trial. The defendant nevertheless chose to exercise his constitutional right to proceed to trial, and the court approved new counsel so the case could move forward with proper preparation. Every defendant has the right to make that choice, but every choice carries legal consequences. Understanding those consequences is one of the most important responsibilities of the court before a trial begins. If you enjoy real courtroom proceedings with professional legal commentary and detailed legal breakdowns, be sure to like this video, subscribe to the channel, and turn on notifications so you never miss our latest Judge Raquel West courtroom highlights. Thank you for watching, and we'll see you in the next courtroom.